MK Stalin 1, RN Ravi 0. That's the scoreline in the battle between the Tamil Nadu government and the governor. The DMK government in the state got a huge boost in its tussle with Governor RN Ravi, thanks to the Supreme Court of India. An angry Tamil Nadu government had taken Governor RN Ravi to court in 2023. The Stalin government was not pleased at all with Governor RN Ravi's conduct when it came to approving bills passed by the legislature. Now, the governor was sitting on these bills for months. No approval, no word, just reserved some of these bills for the president's consideration. 10 of these bills in question, to be precise. Today, the Supreme Court of India gave a landmark judgment. It says these actions by RN Ravi were invalid and unconstitutional. Chief Minister Stalin has called this judgment historic. DMK leaders have begun demanding Governor RN Ravi's resignation. The apex court on its part has made some scathing observations in this case. And it hasn't stopped at just that. It has also clarified a slight ambiguity in the original law on governor approving bills. And the court has also given a timely reminder to governors, Raj Bhavans across the country. Hello and welcome, I'm Shubham Chauhan. Let's get started. India's Supreme Court pulled up Tamil Nadu Governor RN Ravi today. It said that his action of reserving 10 bills for the president was illegal and erroneous. A bench of Justices J.B. Pardiwala and R. Mahadevan underlined that the governor does not have the power to sit on bills indefinitely. It said that the governor must act under Article 200 of the Indian Constitution. Or if he or she doesn't, then that is a constitutional breach. That is something that the court clarified. Now, Article 200 of the Constitution lays down the process of what happens after a bill is passed by the state legislature. This provision states that once a bill is passed by the state, it goes to the governor. The governor has three options: approve the bill, withhold assent, or reserve the bill for consideration by the president. Now, in case the governor picks option 2, that is withholding assent, the bill goes back to the assembly. Article 200 says the governor may return the bill in question as soon as possible along with a message. This message would contain parts or the entire bill where the governor has an objection. Once sent back, if the bill has been passed again and has been resent to the governor cannot and should not withhold the assent anymore. In other words, it has to be approved by Raj Bhavan so that the bill becomes a law. So that's the rule. Now let's come to Tamil Nadu Governor RN Ravi's case. The state government led by Chief Minister MK Stalin said that 12 bills passed by the state assembly between 2020 and 2023 were not given the green signal by Raj Bhavan. Now, by the way, this also includes bills from the previous government, that is the AIADMK government in Tamil Nadu. Governor RN Ravi just did not approve these bills. These bills had to do with aspects pertaining to state universities in Tamil Nadu, like giving the government, the state government that is, more say in appointing vice chancellors than the governor, who by default is the chancellor of state universities. The law basically gave more power to the government than the governor. Other than these bills, RN Ravi also refused to sanction for prosecution of public servants and premature release of prisoners. Like I said, the Tamil Nadu government went to the Supreme Court in November 2023 over this delay on the part of the Raj Bhavan. Now, once the matter reached the court, the governor referred 2 of the bills to the president, but still withheld consent on the remaining 10 bills. The court today called these actions illegal. It also said that Governor RN Ravi did not act in good faith. The apex court declared that a bill is not open for the governor to reserve the bill for president review after it is presented to him or her for a second time. So effectively ruling out the third option we told you about. Now, once it was sent to him the second time, RN Ravi should have ideally given his assent to the bills in question. In an earlier hearing, the Supreme Court that is, also frowned on this delay on the part of RN Ravi. They had observed at the time that Raj Bhavan appeared to have devised his own procedures. The governor, that is, he devised his own procedures when it came to clearing bills. On the governor's inaction and delay in passing the bills, the bench said today, there is no expressly specified time limit for the discharge of the functions of the governor under Article 200 of the Constitution. Despite there being no prescribed time limits, Article 200 cannot be read in a manner which allows the governor to not take action upon this, which are presented to him for assent, and thereby delay and essentially roadblock law-making machinery in the state. Importantly, the court did not stop at this. It laid out a specific time frame as well within which the governor must clear the bills come what may. And these timelines, these deadlines are the following. The first is a 1-month deadline for governors to withhold assent to a bill and reserve it for President's review with the aid and advice of the Council of Ministers. Second is when a bill is reserved without the aid and advice of the Council of Ministers, and this deadline, the deadline for this for the governor will be 3 months. And third, if a bill is presented to a governor after reconsideration by the state assembly, he or she must clear it within 1 month. The Supreme Court added that the failure to comply with these timelines would make it eligible for judicial review. And this is not just a Tamil Nadu specific story. Kerala, Telangana, Punjab, these three states are seeing the same problem. Kerala says 3 bills have been pending with now former Governor Arif Muhammad Khan for more than 2 years and 3 bills for more than a year. Their case is in the Supreme Court because the High Court has refused to intervene in this matter. In Telangana, more than 10 bills are pending with the governor. 7 of these were passed by the Assembly and sent to Raj Bhavan in September 2022. Now mind you, these are bills discussed, debated and passed by an elected assembly, elected members by a state legislature. A governor appointed by the centre, meanwhile, sitting on these bills indefinitely does very well tantamount to becoming an obstacle in governance. Now, the best way to gauge this dynamic between a governor and an elected state government is to just see who rules the state government. So you have a BJP government, the governor would almost be like a friend. If there's an opposition government, the governor would be anything but that. Take Maharashtra post-2019 election, for example, when the BJP-Shiv Sena alliance fell through. Adhering to constitution just went out of the window in a way, as the governor at the time, Bhagat Singh Koshyari, almost became an ally for the ruling party at the centre. Rules were tweaked overnight and loopholes were sort of found to ensure that oath ceremonies involving the BJP are held early morning. Same state today, that is Maharashtra, has a BJP-led government in place and everything is hunky-dory. Similar was the case with former Delhi Chief Minister Arvind Kejriwal and his government's tussle with the Lieutenant Governor in Delhi. In Congress-ruled Karnataka too, there is the same story. And yes, in the Congress era as well, going back years, there are several governors whose actions in several cases were questionable. But in the last decade, this rift between opposition-ruled states, governments and the governor has gotten more pronounced. The point is that this trend of governors becoming almost political arms in an opposition-ruled state is a worrying one. And the Supreme Court today did take notice of this. The court reiterated that a governor must respect the will of the people and operate within the established rules and norms. The court said, and this is a slightly longish quote but pretty pertinent, and I'm quoting from what the court said, the governor must be conscious to not create roadblocks or chokehold the state legislature in order to thwart and break the will of the people for political reasons. The members of the state legislature, having been elected by the people of the state as an outcome of the democratic expression, are better attuned to ensure the well-being of the people of the state. In times of conflict, he, as in the governor, must be the harbinger of consensus and resolution, lubricating the functioning of the state machinery by sagacity, wisdom, and not run it into a standstill. He must be the catalyst. He, again, as in the governor, must be the catalyst and not an inhibitor. All the actions of the governor must be impelled, keeping in mind the dignity of the high constitutional office. Any action to the contrary to the express choice of the people, in other words, the state legislature, would be a renege of the governor's constitutional oath. Now, as we are recording this video, there has been no official comments from the governor's office, that is R.N. Ravi in this case. And like I said, M.K. Stalin has called this decision of the Supreme Court historic. But overall, there were some strong words, like I said at the beginning, used by the Supreme Court of India. Now, to what effect does this change things in Raj Bhavans in opposition ruled states would be very interesting to watch. That's all we have for this report. Thanks for watching.